Well, the incident that happened yesterday was not isolated one because it was further confounded by additional unfolded events this morning. There was an attempt yesterday by the EFCC, which indeed was a co-litigant in respect of a pending criminal proceedings before Federal High Court against my person. Arising from that criminal proceeding, there was an order dated 6th day of January 2026, an interim order for forfeiture that was granted. But the most interesting part of the order, there was no clear directives or instructions in the order that the premises will be taken over forthwith, or perhaps being sold, or perhaps evicting the occupants of the respective premises. But the most interesting part of it is an application was filed at my instance for setting aside the order. And the court fixed a date against the 20th day of April 2026 for the hearing of an application filed at my instance challenging the propriety or otherwise of the order. Conventionally and traditionally, by the act of securing the order by the EFCC and by the act of joining issues on my part by way of filing an application seeking for the court order to set aside, issues are joined by the parties. So it is only natural, logical, legal, and judicial that no party is expected to overreach by way of taking unilateral steps that will place a court in a situation of helplessness. But unfortunately, yesterday, without further recourse to the court, without seeking for an order to seal my properties, without seeking for an order to evict me and my family members from the property, without seeking a court order for the appointment of receiver manager, the EFCC came yesterday to effect forceful eviction. They were unable to conclude on the process yesterday and reinforced this morning with a lot of personnel that are armed and indeed forcefully take over possession of my family residence and the family members who are equally taken out of possession. It is commonplace and it is in line with the tradition of the judicial process that when a matter is pending before a court, you cannot unilaterally act as a party to take steps or perhaps to take steps that will render the court helpless. Traditionally, when you are a party before the court, you cannot on your own embark on execution exercise. Executions of the court orders and processes are exclusive functions of the court bailiffs, court sheriffs, and judicial processes, and not in any way exclusive reserves and prerogatives of a party to the litigation. So what happened by way of forceful eviction of my family members, forceful taking over of my properties, and forceful perhaps invasion of these properties of mine is legally and judiciously unprecedented in the Nigerian history and Nigerian legal system. It has never been a tradition of perhaps relying by an institution or establishment of government on interim orders of forfeiture to force an eviction onto a co-litigant before a court of law. So my take is what is unfolding on the part of EFCC is indeed steps that are extrajudicial, that are unprecedented, that are unlawful, that are illegitimate, and that are now intended apparently to cause a situation of helplessness on the part of the court, which had already fixed the hearing of the application relating to these properties to a certain date, which is fixed for 20th day of April 2026. So I think it is on this basis that it is important for me to put across the situation that is unfolding. For me, the steps are legal, legitimate, and judicial, and we will certainly embark on judicial process to do the needful. Well, the property in contention that has, in respect of which invasion activities had taken place this morning, being the 24th day of March 2026, is my family house at number 2 Coronac Crescent off Amazon Street, Maitama, Abuja. And arising from what they have exhibited, it is apparent that they are embarking on perhaps a multiple enforcement, unilateral enforcement of what they consider an interim order, which order is being challenged before the court, in respect of which order they have been served with a copy of an application for setting aside, and their lawyers equally filed necessary processes. Issues were effectively joined both by my lawyers and the lawyers of the commission, and yet the commission could not exercise the desired restraint to allow for the application, to allow for the judicial processes to be consummated, and they have indeed taken it onto themselves without recourse to the court, without recourse to the judicial mechanisms of the court bailiffs and court sheriffs in the implementation of the court order. Even if indeed there was express directives of the court to seal the property, there was express directives of the court to evict my person and my family members from the property, or perhaps to appoint a receiver manager. The implementation and execution of those processes are judicial functions, and not functions that are peculiar or perhaps exclusive to the, that are the prerogative of a litigant, and I'm talking of EFCC for that matter. EFCC and Abubakar Malami are the parties before the court in the circumstances. So the idea of one of them, either the EFCC or Abubakar Malami, to initiate processes without recourse to the court is unprecedented in the Nigerian history. EFCC, as a party before the court, cannot enforce the order, even if indeed they were granted an express order for eviction of my person, an express order of taking over my property, an express order of perhaps appointment of a receiver manager, which in the circumstances needs to be litigated by the parties before the court. Well, as far as political ambition is concerned, it is common knowledge, one, that I have been a politician over time, and I am deeply rooted in politics and political processes. And it is common knowledge that I have been taken to custody for around 99 days. And immediately after my release from detention, which detentions were mostly were initiated at the instance of the EFCC, people of goodwill, particularly among the politicians, have been paying solidarity visit onto me. So the fact that these things happen at a time when I was receiving tremendous goodwill messages, solidarity visits, and courtesies can certainly be a basis for people to insinuate perhaps the political persecutions associated with the conduct of any agency, any federal government agency. So people are free to insinuate those things, and I think that those insinuations of political undertones cannot legitimately be displaced. Well, the media, I think the role of the media is to make the public adequately informed about the prevailing circumstances. So my take is a call on the media to do their work dispassionately without fear or favor. As for the government, I think the position of the law is clear, that the idea of when things are taken through judicial processes, it is only logical that the judiciary should be allowed to take its course and not to allow any institution of government to unilaterally take steps that could be detrimental to judicial determination of cases that are pending before the court.